they buried it. A federal panel just handed down one of the most consequential Second Amendment rulings in a generation, and the mainstream media treated it like it never happened. No breaking news banners, no primetime analysis, no front pages, just silence. And that silence is deliberate, because what this ruling does threatens an entire system that powerful people spent decades building. If you carry a firearm for self-defense, if you have ever stood in line at a government office and filled out forms begging the state for permission to exercise a constitutional right, or if you live in a state where a local sheriff gets to decide whether your life is worth protecting, this ruling just changed your world, and you deserve to know exactly how. So that is what we are going to do right now, because the people who should be screaming about this from every platform available are staying quiet. The concealed carry permit system is under direct federal legal attack. It came down unanimous, and the implications stretch far beyond any single state or case. Stay with me. Hit that subscribe button right now if you believe that information this important should not be buried by people who profit from you staying uninformed. This is the conversation they do not want you having. Let us start with the foundation, because to understand why this ruling matters, you need to understand what the permitting system actually is and what it was never supposed to be. The Second Amendment is 4 words at its core: the right to keep and bear arms, not the privilege, not the opportunity, the right. And yet for decades, in state after state across this country, exercising that right in public required you to go hat in, hand to a government office, fill out paperwork, pay fees, submit to background checks, sometimes wait months, and then only then receive a card from the state that said you were allowed to do what the Constitution already guaranteed. Think about how absurd that is when you hold it up to the light. Imagine if the government told you that you could attend church, but first you needed to submit an application, pass a review process, and receive a worship permit. Imagine if your local police chief had the authority to look you in the eye and tell you that in his personal judgment, you did not have a good enough reason to exercise your First Amendment rights. You would call that tyranny. You would be right to call it that. But that is precisely what millions of Americans have been living under when it comes to their Second Amendment rights. And most of the country either never noticed or decided it was acceptable. A coalition of gun rights organizations decided it was not acceptable and took that fight to federal court. They argued that the permitting framework itself, not just how it was applied, but the framework as a structural mechanism, violated the Second Amendment as understood through historical analysis. And they won. The court went back through the historical record, examined what the founders actually intended when they enshrined this right into the Constitution, compared that to the modern permit regime, and found that the current system exceeded what that historical record could justify. In plain English, they found that the government went too far, overstepped, and built a bureaucratic wall between citizens and a right that was supposed to be theirs, without condition. That is not a narrow ruling on procedure. That is a frontal assault on the entire architecture of how this country has managed the public carry for generations. Now let us talk about what this actually means on the ground for real people, because legal language is one thing and lived consequences are another. Before this ruling landed, if you wanted to legally carry a concealed firearm in a public space, you were at the mercy of your state government in what are called May issue states, and there have been several of them operating well into 2026. A local official had enormous discretionary power over whether you received a permit at all. You could be a law-abiding citizen with 0 criminal history, a clean background check, and a completely legitimate reason for wanting to protect yourself. And a county sheriff could still look at your application and say no, no explanation required, no meaningful avenue for appeal in many cases. Just no, the right existed on paper. In practice, for people in those jurisdictions, it was effectively locked behind a gate, controlled by whoever happened to hold local political power. What this ruling does is kick that gate off its hinges. It says the government cannot require you to get permission to exercise a right that already belongs to you by default. And that is not just a procedural shift. That is a philosophical realignment of the entire relationship between the citizen and the state when it comes to self-defense. Before this ruling, you had to prove you deserved to exercise your right. You had to demonstrate good cause. You had to satisfy a bureaucrat. After this ruling, the burden flips. Now the government has to prove you should not be allowed to carry. They have to show you are dangerous, that you have been legally disqualified, that there is a specific and articulable reason grounded in law to prevent you from exercising your constitutional right. And that inversion is enormous. And then consider the downstream effects rippling out from that shift. And federal agencies, the ATF, the FBI, others, built their operational infrastructure around a system where permit holders were tracked, vetted, and logged through state authorities. Their databases, their enforcement protocols, their training programs all assumed that states would be functioning as gatekeepers. When that gatekeeper function disappears, pieces of their enforcement architecture start losing critical inputs. That is not a small administrative problem. That is a systemic disruption, and those agencies are already scrambling to figure out what their role looks like in the new landscape. Here is where it gets personal and specific, because you need to think through what this ruling means for your actual life, depending on where you live and how you carry. Let us walk through 3 scenarios that are already playing out for gun owners across the affected jurisdictions in 2026. If you live in a state that had a May issue permit system, you were living under some of the most subjective and arbitrary gun laws in the country. Local officials had wide discretion to deny your application based on their personal assessment of whether you had sufficient need for self-defense. That system is now legally indefensible under this ruling. You no longer need to prove to someone else that your life is worth defending. The state now has to demonstrate that you specifically should not be armed. And that is a fundamentally different and far more demanding legal standard for the government to meet. If you are in a shall-issue state where the law theoretically required the state to issue you a permit if you met the objective criteria, you might think this ruling is less relevant to you. It is not, because many of those states designed their permitting systems with layers of requirements that functioned as obstacles even within a shall-issue framework. Mandatory training requirements with narrow approval windows, application fees structured to price out lower-income applicants, waiting periods that stretched on for months. All of those elements are now under serious legal pressure. The question going forward is whether your state will use this ruling as an opportunity to streamline and honor the constitutional framework, or whether it will scramble to replace the old system with new restrictions wearing a different name tag. Watch your state legislature closely. The third scenario is the one that requires the most vigilance. Traveling between states with your firearm. This ruling does not cover every state simultaneously. The direct legal effect applies to states that fall under the jurisdiction of the issuing court. Other states are affected indirectly through the precedent this sets, but the legal landscape varies dramatically from one state line to the next. You cannot assume that what is legal for you in your home state is legal the moment you cross into another jurisdiction. The map of where you can legally carry is going to look very different at the end of 2026 than it does today. And it is going to keep changing as courts, legislatures, and law enforcement agencies all respond to this new reality at different speeds. Do not make assumptions. Know the specific laws of every state you drive through. Your ignorance of what changed is not a legal defense. Now, I need to stop and address the noise, because when a ruling like this drops into the information environment, the misinformation machine kicks on immediately and it runs hot. People share clips without watching full explanations. Talking heads on both sides overstate or understate what actually happened, and the result is that gun owners end up acting on information that is either dangerously wrong or dangerously incomplete. So let us cut through it hard and clear. The first thing circulating right now that is flatly wrong. People are saying this ruling means you can now carry a gun anywhere in the country without any restrictions whatsoever. That is not what happened. The ruling addresses the permitting requirement. The mechanism that required you to get government approval before carrying it does not wipe out laws governing where carrying is permitted. You still cannot carry into federal buildings. You still cannot carry into schools, airports, courthouses, government facilities. All of those prohibitions remain intact, and violating them still carries serious federal criminal consequences. Private property rights also remain intact. Business owners retain the legal authority to prohibit firearms on their premises. And that is not something this ruling touched. What changed is who has the right to carry in legal public spaces. What did not change is where carrying remains legally prohibited. Those are two completely different questions, and conflating them could get someone arrested. The second dangerous myth, people are claiming the ruling has already been stayed or reversed by a higher court. As of right now, that is false. The ruling is, in effect, the case is moving through the legal system and appeals are coming, because of course they are, but what exists right now is real, it is operational, and it is already reshaping how states and law enforcement are responding. Anyone telling you this ruling has been neutralized is either misinformed or lying to you. The third myth, doing serious damage. People are telling each other that existing permits are now worthless and should be discarded. Do not do that. Your permit may still provide meaningful legal protection in states that are not directly covered by this ruling. It may still function as a useful document in encounters with law enforcement officers who are still operating under the old framework and have not yet been updated on how the legal landscape has shifted. It may open doors in states that maintain their own permit requirements under state constitutional authority, which this federal ruling does not necessarily override. Throw your permit away and you may lose protections you do not realize you still have. The fourth myth, that this applies to all 50 states right now, today. It does not. Jurisdiction matters. The ruling is directly binding in the states under the circuit court that issued it. Other states are influenced by the precedent, but the direct, immediate legal compulsion is geographically limited. Know which category your state falls into before you change how you carry. This is exactly why being informed, specifically, accurately, and continuously, is not optional. It is the difference between exercising your rights and accidentally surrendering them by misunderstanding what the law now says. Hit that subscribe button, turn on notifications, because when this moves, and it is going to move fast in the coming weeks, you need to be in the room when it does, not catching up after the fact. Let us talk about what is coming, because this ruling did not end a fight. It opened one. The political and legislative response from the other side of this debate is going to be aggressive. It is going to be fast. And if you are not watching for it, it is going to roll back what this ruling achieved in ways that are hard to see coming. State legislatures that relied on their permitting systems as tools to limit who could carry are already in emergency. Crash session in some jurisdictions. Their lawyers are working overtime to draft new statutes that accomplish the same practical outcome, restricting who can legally carry while using language that is designed to survive the new legal standards set by this ruling. They will call it a safety training mandate. They will call it a competency certification requirement. They will wrap it in language about public safety and responsible gun ownership. But if the practical effect is that the government still controls who gets to exercise a constitutional right through a bureaucratic gatekeeping process, courts are going to see through the costume and apply the same constitutional analysis. That battle is going to be fought in courtrooms across the affected jurisdictions over the next 2 to 3 years, and it is going to generate some of the most significant Second Amendment case law we have seen since Bruin in 2022 and Peller in 2008. The federal agency response is its own story. The ATF in particular is facing a structural problem. For years, the permit system functioned as a passive vetting and tracking mechanism that supplemented federal background check systems. State permit databases gave federal law enforcement a layer of intelligence about who was legally carrying in public spaces. As states dismantle those systems in response to this ruling, federal agencies lose that layer. They are going to push Congress for new legislative authority to compensate for what they are losing. Watch for proposals in the coming months that try to create a federal-level permit or registry system to replace what the states are unwinding. That fight will be intense, and it will be framed as a public safety necessity by everyone who wants to preserve the gatekeeping function through federal rather than state authority. And then there is the chain reaction effect on other Second Amendment cases that have been trapped in legal limbo waiting for exactly this kind of precedent. There are cases sitting in federal courts right now challenging magazine capacity limits, challenges to assault weapons bans, challenges to waiting period statutes, challenges to red flag law frameworks. And all of those cases just got a massive infusion of legal momentum from this ruling. When one major barrier falls in constitutional law, the cases stacked behind it start moving. This is not the end of a legal battle. It is the beginning of the most consequential phase of Second Amendment litigation in modern American history. And the side that is trying to hold back the tide knows it. That is why you are seeing the media downplay this. That is why the political establishment is staying quiet rather than engaging directly, because engaging directly means acknowledging that the constitutional argument has merit. And that is a conversation they have spent decades trying to avoid having. Here is what I want to leave you with, because this story is bigger than any single ruling, and it is bigger than any single right. What we are really talking about is what kind of relationship American citizens are supposed to have with their own government. The founders did not write the Bill of Rights because they trusted government to be generous. They wrote it because they understood that governments expand, that power consolidates, and that rights require structural protection to survive. The Second Amendment was not an afterthought or a hunter's benefit clause. It was a deliberate recognition that the right of individuals to defend themselves, their lives, their families, their communities could not be made contingent on government approval without becoming something fundamentally different from a right. A right you have to ask permission to exercise is not a right. It is a privilege extended at the discretion of whoever controls the permission process, and privileges can be taken away without due process, without constitutional protection, without accountability. That is what the permitting system had become in far too many states, not a safety mechanism, a control mechanism. This ruling pushes back against that hard, and it should, but here is the part that does not get said enough. Expanded rights come with expanded responsibility. If more people are legally armed in more public spaces, and that is exactly what this ruling enables, then every single gun owner in this country has an elevated obligation to take their responsibilities seriously. That means training, real training, not just range time, but situational awareness, de-escalation, understanding the legal framework for justifiable use of force in your jurisdiction. It means knowing the laws of every state you travel through, not just the state you live in. It means carrying yourself with the discipline and the gravity that comes with holding lethal force in your hands, because you are not just responsible for your own safety in a crowded public space. You are a variable in everyone else's safety equation too. The attorneys who argued this case described it as one of the most significant Second Amendment victories in generations. They are not wrong. But a legal victory is only meaningful if the people it protects understand what it means, understand what it does not mean, understand their responsibilities under the new framework, and stay engaged as the legal landscape continues to evolve. Because this is not over. Appeals are coming. Legislative workarounds are being drafted right now. Federal agencies are going to push for new authority. The other side has resources and has institutional relationships, has media access, and is not going to accept this outcome without a prolonged, well-funded fight. That means the community of people who care about these rights, the people watching this right now, cannot afford to disengage. This channel exists because this information matters and because you deserve to receive it without spin, without partisan packaging, and without the filter of people who profit from you staying confused and passive. And the mainstream will not do this work. Cable news will not do this work. The platforms that are built around institutional access and advertiser relationships will not go where this conversation needs to go. So I will, and I need you here with me when I do. Subscribe. Turn on the bell so you do not miss a single development as this unfolds. Drop a comment telling me what part of this ruling concerns you most, or what question you still have that nobody has answered for you yet. Share this with every gun owner you know who carries, because the information gap right now is dangerous, and the only way to close it is to pass real information to real people who need it. You found this. Make sure someone else does too. The rights you protect by staying informed are not just your own. They belong to everyone who comes after you.